Hi everyone, is everyone around? Or shall we wait until 2:30 to start the webinar? I think we can wait for a couple more minutes and we shall start sharply at 2:30 p.m. Hi, good afternoon everyone. I think we will start our webinar now. Just to introduce myself, my name is Lisa, and together with me today is Rachel, my colleague, and we're both a legal associate in the litigation department of RDS. And today's topic will be on the housing development in Malaysia and how it protects home buyers. So today, both the speaker will be just myself and Rachel. We will first go through the developments of the law and what issues that we are facing, and how, and I think we can reserve the Q&A to the very last portions of the webinar, where if you have any questions, feel free to raise your hand and we'll try our best to answer your queries. Next slide, please. So housing developments in Malaysia. There are 9 agendas for today's webinars, as you can see from the screen. Firstly being, what are the governing laws of the housing development? Secondly, what is the objectives of the Housing Development Act? Who is bound by the Housing Development Act? The importance of the Housing Development Act? What is the scope of the Housing Development Act? What type of properties are protected by the Housing Development Act? What type of properties which are not protected by the Housing Development Acts? What are the issues revolving housing developments? And lastly, how COVID-19, as usual, like how it impacts everything else, is impacting the housing development generally as a whole. So as you are aware, purchasing a property always comes with like a careful evaluation by all home buyers, as I believe it is a big decision given the amount of money that's at stake. So many new home buyers are not aware that their interests are actually protected under the existing legislation, which is called the Housing Development Act, established in 1966. Often, purchasers who are not first-time buyers do not have, who are first-time buyers, do not have experience in the real estate world. They tend to have lesser bargaining power as compared to housing developers who have been in the industry for many, many years. So with that being said, all these experienced housing developers might take advantage of first-time home buyers. Hence, it is important for housing development, which will help these purchasers to stand a better chance in getting a fair deal. Essentially, the Housing Development Act is the mother of all housing development regulations in Malaysia that protects the interest of residential title home buyers against developers for a specific period. I'll explain this further later. But if you plan to buy a residential property, here's what you need to know about housing development. First of all, what is housing development? The primary legislation is known as the Housing Development Act, as you can see. It was formerly known as the Housing Developers Control and Licensing Act 1968. This act has been in existence for more than 50 years since its inception. Apart from the principal act, the housing developers in Peninsula, the slides before, please. The housing developers in Peninsular Malaysia are also governed by regulations like the Housing Developers Control and Licensing Regulations 1989 and the Housing Developers Housing Development Account Regulations 1991. The Act has undergone several amendments to regulate residential developers better and keep it in sync with the existing challenges of home buyers. Each amendment has always resulted in stricter rules being imposed on developers and for greater protections of home buyers. So now we'll go into what are the objectives of the Housing Development Act. The main objectives of the HDA are, firstly, to provide, the control and licensing of the business of housing development in the Peninsula of Malaysia. Secondly, to the protection of the interests of the purchasers. And thirdly, as well, it's for all matters connected to the HDA therewith law. So what is housing development? What amounts to housing development is actually defined in Section 3 of the Act to mean the construction and sale of more than 4 units of housing accommodation. In addition, it also includes the sale of more than 4 units of housing lots by the landowner or his nominee with the view of constructing more than 4 units of housing accommodation by the said landowner or his nominee. On the other hand, the term housing accommodation has been defined explicitly in the Act to include any building tenement or messuas which is wholly or principally constructed, adapted, or intended for human habitation or partly for human habitation and partly for business premises. In essence, therefore, the Act only applies to cases where a housing developer is undertaking the development of at least 5 units of housing accommodation. That is to say, to complete housing units, whether it's houses, flats, apartments, partly houses, and partly shop or offices. So the next thing is to ask, who is actually bound by the Housing Development Act? Technically, all housing developer in Malaysia is bound by the Act, in which they have to first get a license before engaging in any housing development. The term licensed housing developer is defined in Section 3 of the Act as any housing developer licensed under Section 5 to engage in or carry on or undertake a housing development, and includes the holder of any power of attorney of such housing developer duly created under the Powers of Attorney Act 1949. On the other hand, a housing developer is described as any person, body of persons, company, firm, or society by whatever name described who or which engages in or carries on or undertakes or causes to be undertaking a housing development. So examples of licensed housing developers in Malaysia, as you can see from the slides, are SP Setia Berhad Group, Gamuda Land, Sunway, and Simdabi Property. So why is HDA so important? Since HDA's implementation, its purpose has always been to safeguard the interests of buyers. Besides that, each of its amendments is in the effort to regulate better residential developers and tackle arising issues in the industry by imposing stricter rules and greater protection, and to ensure there are fairness to the purchasers. So HDA prevents housing developers from taking advantage of buyers and to ensure that there is fair practice in the real estate industry. What does HDA cover? HDA plays a crucial role in comprehensively protecting buyers' interest of primary market residential properties for a specific period of time. Other crucial roles of having the HDA are: it provides for a prescribed SPA agreement. Secondly, advertising permit and developer's license, which we will elaborate further later. Thirdly, HDA account. Fourthly, home buyer tribunal. And lastly, abandoned housing projects. My colleague Rachel will take it from here now.
Thank you, Lisa. Hi everyone, I'm Rachel. So now, one of the complex issues for home buyers is going through the SPA, which is the sale and purchase agreement. So what is SPA and why is it so important? SPA is an agreement that basically covers the purchase. It is extremely important to read and understand everything properly before signing it. So to safeguard the buyers, the Act has mandated a standard format for the sales and purchase agreement. This also means that the developer has no liberty to remove the protection given to the purchaser in the standard agreement. Any terms inserted by the developer to change the agreement are not valid. So there are different schedules for SPA under the HDR, which are issued according to the type of property and its purchase method. So for instance, Schedule G of the 1989 regulations is for the sale and purchase of landed properties. The property units under this category are sold under individual titles, which will be issued to the home buyer. When you complete the purchase, the plot of land and building will be under the home buyer's name. Whereas for Schedule H, which is for strata properties, it involves a more complicated than the earlier Schedule G, as it includes the ownership of common properties and your rights to them. Hence, both Schedule G and H are in the STB concept, which is sell then build concept. Schedule I is for the sale and purchase of landed property, which is bought through a different method, which is the BTS concept, build then sell concept. So under Schedule I, purchasers can see the fully completed unit before deciding to go ahead with their purchase. As for Schedule J, this will be for the purchase of strata property delivered through that very same BTS concept. So in this concept, you are only required to pay 10% of the purchase price on the date of the signing of the SPA with the developer, while the balance of 90% is to be paid after the completion of the property. Often, buyers are not thorough with either the procedure or the details of the SPA, but now the HDA has mandated a standard format for the purchase agreement. No matter the type of residential property, developers must adopt a standard agreement prescribed by the HDA. So next, There is no force majeure clause in the standard SPA under the HDA. This can be seen in the case of SEA Housing Corporate Sdn Bhd and Lipo Chu. In this case, buy a shop house from the defendant, a licensed housing developer. Under the agreement, the defendant was to complete the said building within 18 months from the date of the agreement. However, the building was completed 23 months and 15 days late, which led to the plaintiff seeking liquidated damages. Clause 32 of the agreement reads that the defendant shall not be liable if the fulfillment is hindered by force majeure. The defendant argued that the delay was beyond his control due to the then building and the resulting shortage of building materials and labor. Nevertheless, the court held that the clause is void for being inconsistent with Rule 12 of the 1989 regulations. In fact, had the developer attempted to persuade the controller for an extension of time, he would have escaped the liability. But developer made no attempt to do so. Thus, the court would not allow the developer to take advantage of such a clause to delay the delivery of the vacant possession at their own discretion. So the other issue is whether force majeure clauses can be implied into the SPA. So this issue can be seen in the case of Chut Yo Hin and another, and Saujana Triangle Sdn Bhd and another. The plaintiff in this case entered into a SPA for a condominium. The delivery of vacant possession was delayed by some 2,658 days from the initial date. In addition to that, there was also 2,645 days of delay for the completion of common facilities. Hence, the plaintiff was claiming for liquidated ascertained damages. The defendant argued that the force majeure clause impliedly existed in the SPA. And since the SPA the court held that the provision for force majeure could not be found in the SPA. And since the SPA is a statutory contract provided for in Schedule H, where the terms and conditions are fixed by law, there is no such implication. So next, there are some clauses in the prescribed SPA which is important. Firstly, progressive payment schedule, where payments to the developers depend on the state of the development's progress. This is to prevent developers from declaring bankruptcy or abandoning the project with all the buyer's money. There will be a schedule of payment depending on the stage of development's progress. The main stages of payments, as seen in Clause 5, third schedule of Schedule G are, firstly, the signing of SPA. Secondly, will be the completion of various development stages. Thirdly, vacant possession for application for subdivision of the building. Fifth will be the final payments. Next clause will be in relation to the deadline to deliver vacant possession. So under Schedule G, which is for the landed residential, developers have 24 months upon the date of signing the SPA. While under the Schedule H, which is for strata residential, developers have 36 months upon the date of signing the SPA. So that means that both the buyer and the seller are bound by this date to deliver and accept on a predetermined schedule. Next clause will be prescribed SPA also includes a defect liability period. Essentially, a warranty period for a new house which lasts 24 months from the date of delivery of vacant possession. So within this period, one can file a report with the developer for any defects. The law has made it compulsory for the developer to make repairs at no cost to the buyer. HDA ensures that developers have APDL, which is advertising permit and developer's license, before placing This can be seen in Regulation 5 of the 1989 regulations. So this is an advertising license given by the local housing authority to developers. APDL is both a sales permit and a housing development license to allow authorities to monitor and regulate property developers. It is introduced to ensure developers have proper authorization and compliance in advertising the sale of the property to prevent deception and false advertising. Besides that, APDL contains information about developers in which buyers could take legal action against the developer if there is any violation of the law. The newly amended 1989 regulations has included regulations 8(1)(a), where it prohibits advertisement of housing developments that offer free legal fees, projected monetary gains and rental income, claim of panoramic view, traveling time from housing projects to popular destinations, and any particulars to which a housing developer cannot genuinely lay proper claim. Section 7(a) of the Act has made it mandatory for a licensed housing developer to open and manage a housing development account with a bank or finance company. This is to ensure that developers channel monies, payments received from buyers into their HDA account to be used to pay for items such as quit rent, assessment rates, taxes, cost of constructions, insurance premiums, stamp duty, and etc. So now let's see part of the HDA 1966. Section 16(b) of the Act has stated that the establishment of a tribunal, known as Tribunal for Home Buyer Claims, which was set up to enable home buyers who have difficulty getting developers to repay their house to submit a claim to get quicker and cheaper solutions. The proceedings before the tribunal are open to the public. The Home Buyers Tribunal can only deal with claims worth 50,000 ringgit or below. This means that the maximum amount the Home Buyers Tribunal can award a home buyer is 50,000 ringgit. However, the tribunal may still hear the claim where it exceeds 50,000 ringgit if both parties agree in writing for the tribunal to hear the claim, or where the home buyer limits his claim to only 50,000 ringgit. Therefore, if the intended claim is worth much more than 50,000 ringgit, it is probably the wiser option to simply proceed to bring legal proceedings in court to obtain a judgment against the housing developer. Depends on the facts of the case. It should be noted that a claim made to the Home Buyers Tribunal must be made within 12 months from either the date of issuance of the Certificate of Completion and Compliance, which is CCC, of the housing accommodation, or the expiry of the defects liability periods as set out in the XPA, or the date of termination of the sale and purchase agreement if the agreement was terminated before the date of issuance of the CCC. It is sad to say that there's a total of 281 private housing projects comprising of approximately 74,000 housing units were confirmed to have been abandoned in Peninsular Malaysia from 2009 to mid-2020, which has involved more than 45,000 of buyers. Section 18(a) of HDA 1966, which came into force in 2015, has covered the consequences of a developer who abandoned or caused to be abandoned a housing development. So firstly, how does the Developers Act amount to an abandonment? Abandon means refuse to carry out or delay or suspend or ceases work continuously for a period of 6 months or more beyond the stipulated period of completion as agreed under the sale and purchase agreement. The effect of it is that the licensed housing developer shall be guilty of an offence and shall be liable to a fine within of 250,000 ringgit Malaysia to 500,000 500,000 ringgit Malaysia or to an imprisonment of a term not exceeding 3 years or both. So now let's see what are the properties protected by the HDA. It is important to note that not all properties are covered by the HDA, as HDA only protects properties and developments of residential titles. But there are special circumstances where commercial title residences and sub-sale projects will be protected too. So for examples of protected commercial title residences are SOHOs, service apartments, and etc., which and partly used as residence. As for sub-sale projects like landed residential properties, which are usually warranted against defects for 24 months, it is still protected by HDA if the sub-sale occurs within this 24-month period. So a strata titled property will also get additional legal protection under two other acts, which is Strata Title Act 1985 and Strata Management Act 2013. Properties which are not protected by the HDA, which is a fully commercial property, including but not limited to retail shops, office spaces, business suites, and industrial units, which will not be protected under the HDA, as they are essentially offices or retail businesses and are not meant for dwelling purposes. The same goes for sub-sales property, which has passed its defect liability period. Such property is sold on an as-is basis, which means a purchaser agrees to buy the house as it is after SIT inspection. Purchasers will need to carry out their own due diligence work and be careful to check all details and terms of the SPA before signing to avoid any future dispute. There are several issues revolving house developments in Malaysia. Firstly, is that the developer has to deliver vacant possession to the purchaser within the time limit stipulated in the prescribed SPA. Under Clause 24.1 of Schedule G HDR 1989, housing developers are required to deliver vacant possession of a landed home with an individual title within 24 months from the date of the SPA. As for strata titled properties, such as condominiums and apartments, Clause 25.1 of Schedule H HDR 1989 provides that it has to be within 36 months from the date of the agreement. The terms of the SPA are statutory terms that must strictly adhere to and cannot be varied or contracted out. The position is made clear in the Court of Appeal case in Ankuni Development Syndrome Berhad and Robert Geoffrey Goch and another. The developer cannot delay or extend the date of the delivery of vacant possession as it is an attempt to vary the terms of the SPA. In some instances, a developer would argue that the delay in delivery vacant possession is allowed as long as the developer has successfully applied for an extension of time from the controller. This perhaps due to the wording of Regulations 11, where controller was given the power to grant an extension. However, it is important to note that such power given to the controller to waive and modify the terms and conditions of the SPA by approving such an extension of time is ultra-rare. This was decided in Ang Meng Lee and others and Menteri Kesejahteraan Bandaraya, Perumahan dan Kerajaan Tempatan and others. The Federal Court held that the controller of housing does not have the power to grant such extension to waive or modify the terms of the SPA in the statutory forms, be it Schedule G or Schedule H. Such an application for an extension of time is void as it would exceed the powers of the controller under HDA 1966. Hence, the developer must deliver the vacant possession with the agreed timeline stated in the prescribed SPA. So the second issue will be the delay in completion and penalty, which is the liquidated ascertained damages, LAD in short. So if the purchaser's new home is not handed over to the purchaser within a stipulated time frame, the purchaser will suffer some form of finance loss and is able to compensation under the clause liquidated ascertained damages, LAD, in the SPA. LAD is a genuine pre-estimate of the loss that will cost to one party in a situation where the contract is breached by the other. So pursuant to clause 24.2 of Schedule G HDR 1989, if the developer fails to deliver the vacant possession of the property within the stipulated time, the developer shall pay the purchaser liquidated damages calculated from day to day at the rate of 10% per annum of the purchase price from the expiry of the period stipulated until the date the purchaser takes vacant possession of the property. On the 19th of January, the Federal Court delivered a landmark ruling in the law of housing development in the country. The decision was delivered in PJD Regency Sdn Bhd and Tribunal Tuntutan Pembeli Rumah and other appeals. So the essence of this case is whether the date for calculation of liquidated agreed damages begins from the date of payment of deposit or booking fee or initial fee of his written intention of purchase, or from the date of the sale and purchase agreement. So the purchasers contended that the date of calculation starts from the date of booking fee is paid, while developers argued that the SPA should be read literally, where it should start from the date stated in the SPA. The Federal Court addressed three principal issues in its judgment, which were as follows. What is the start date to calculate LAD? What is the cutoff date for LAD calculation? And thirdly, how to calculate LAD? I'll now pass the floor to my colleague Lisa.
Thanks, Rachel. So I think this is quite an interesting topic for an LAD. I guess all home buyers would be interested to know whether they are entitled to LAD. And now I'll go straight up to discuss how we could start the date to calculate LAD. So from the literal reading of clause 24, Schedule G of the HDA 19, the commencement of LAD should start one day after 24 calendar months from the date stated in the SPA. So there are actually several different key dates through the process of purchasing the property. So some would say that it's upon payment of booking fees. Some would say it's upon the purchaser signing the SPA. Some would say that it's upon the developers signing the SPA. So how do we determine which of these dates would be the starting date for us to calculate the LAD? So prior to the decision in PJD Regency, there were actually two conflicting Court of Appeal decisions wherein related to the calculation of LAD on whether time starts from the date of payment of the booking fee or from the date of signing of the SPA. In GJH Avenue, Sdn Bhd against Tribunal Tuntutan Pembeli Rumah, the Court of Appeal actually took a literal approach and found that where the collection of deficit is actually prohibited by law. Hence, LAD should actually be calculated from the date of signing of the SPA. On the other hand, the Supreme Court in the case of Ho Si Sen and another against Public Bank Berhad and Faber Union Sdn Bhd against Chew Nyat Shong and another actually supported the proposition that the calculation of LAD should actually begin from the date of payment of the booking fee. Hence, PJD Regency is a case where the Court of Appeal actually affirmed the position in the case of Horsey Sen held by the Supreme Court. And in PJD Regency, the Federal Court actually emphasized that the Act and the regulations are a social legislation and differs from any other legislation. So the Act itself and the regulations are actually pertinent for the legislature to mitigate the inequality of bargaining power that may exist. So this is actually in line with the Parliament's intention to protect buyers of housing development. So when do we know what is the cutoff date of LAD? The question is whether the cutoff date is the date of the CCC, which is the CPC, Certificate of Practical Completion, or the date of the CCC, Certificate of Completion and Compliance. The developer's architect issues the CPC to the main contractor to confirm that a work undertaken by the latter has been completed to the satisfaction of the developer's architect, whereas on the other hand, the CCC is issued to certify that the property, together with the common facilities, have been constructed and completed in conformity with the approved plans and the relevant laws. Hence, the court held that for purposes of ascertaining the date of the completion of the common facilities, the relevant date is actually the date of issuance of the CCC. The CCC is issued to certify that the property and the common facilities have been constructed and completed with the approved plans and requirements of the Street, Drainage and Building Act 1974 and its bylaws. So what are the methods to calculate LAD? I think everyone will be asking whether the LAD shall be calculated based on the rebated purchase price or the actual purchase price as shown in SPA. I think it's a common practice these days where developers would actually offer some discounts towards the purchase price. So whether the LAD shall be calculated from the price that you actually paid for or the actual price of the property. The Federal Court in PJD Regency ruled that LAD should be calculated based on the price stated in the SPA instead of the rebated purchase price. The Federal Court stated that rebates are essentially ex post facto discounts amounting to refund of monies already paid by the purchaser. The concept behind LAD is aimed to compensate purchasers for the developer's failure to comply with the timeline set by statute. Therefore, any rebate on the purchase price granted by the developer to the purchaser is to be disregarded from the calculation of the LAD. By the Federal Court ruling of PJD Regency, the objective of the housing laws in the country is to protect the interests of home buyers. Developers are advised to ensure that their practices are in line with the applicable principles under the HDA and do not deviate from the statutory contracts to safeguard the interests of home buyers. Next, on the issue of the right to set off, where the developer owes the buyer LAD, can the sum be set off by the amount the buyer owes the developer? In the case of SEA Housing Corporation Sdn Bhd against Lee Po Chu, the Federal Court held that the purchaser withheld payment of the amount demanded by the housing developer by way of set-off against the balance of the purchase price, the LAD, which is actually due to the purchaser. The issue in this case is whether the purchaser, in withholding payment of the last installment due to the breach, committed a breach of the agreement. The Federal Court held that the purchaser did not breach the agreement when she withheld payment of the amount demanded by the housing developer. The rationale being the purchaser's cross-claim and the housing developer's claim was so closely connected that it would be manifestly unjust to allow the housing developer to enforce payment without taking into account the purchaser's cross-claim. Next, on the right to terminate. The purchasers actually have a unilateral right to terminate the SPA. Pursuant to Section 8A of the HDA Act, a purchaser is entitled to terminate the SPA if the licensed housing developer refuses to carry out or delay or suspend or cease work for a continuous period of 6 months or more after the execution of the sale and purchase agreement, in which it has also been certified by the controller and has obtained a written consent from the end financier. I believe everyone would be aware that since COVID-19 started last year, it has actually impacted our life drastically, not just in terms of work, in terms of your life. We can't even fly off the country. We can't even dine in. So of course, this COVID-19 has also impacted on the housing development. The COVID-19 Act 2020 is gazetted and came into effect on the 23rd of October 2020, has modified several provisions in the HDA in 1966. Firstly, it prohibits the developers from imposing late payment charges on buyers for unpaid property installments from the day MCO started, i.e. the 18th of March to 31st of August 2020. It also excludes the period of 18th of March to 31st of August 2020 from the calculation of the defect liability period. Hence, the home buyers may actually apply to the minister to extend the period up to 31st of December last year. The period between 18 March 2020 and 31st August 2020 is also excluded from the calculation of the time for delivery of vacant possession of a housing accommodation and the computation of LAD for the developer's failure to deliver vacant possession of a housing accommodation will exclude the prescribed period. Housing developers may apply to the minister to extend the period up to 31st December 2020. The reliefs under the COVID-19 Act provide a breather for both the housing developers and purchasers as time stop running during the prescribed period, which is from the 18th of March last year, the COVID, since lockdown, up until 31st of August. However, both parties, be it the purchaser or housing developers, can apply to the minister to extend up until the 31st of December 2020. In conclusion, investing in a house is often a once-in-a-lifetime affair for most Malaysians, where they gather their life savings to buy a house, buy a comfort place for your family. Therefore, the HDA is pretty much one of the most important forces that ensure fair practice across the real estate sector in Malaysia, and at the same time, safeguard the buyer's interest. I urge home buyers, especially first-time home buyers, to do more research and to keep yourself updated on the law in order to protect your own interest. Thank you. So now it's Q&A session. Is it possible for housing developers to extend time in delivering vacant possession? The short answer is yes. However, it is it has to be a mutual agreement. So for that to happen, the buyers have to actually agree to such extension before a housing developer could actually extend the time in delivering the vacant possession. If a force majeure clause is not included in the SPA, can it be taken as an implied term in the contract? No. Actually, this has been clearly stated in the case of Chut Yu Hin and another against Saljana Triangles and Nurem Berhad and another, where the court has actually stated that the terms of the SPA, as seen in Schedule G and H, are actually considered as statutory in nature, and it is not ordinary contract where parties are able to negotiate before the terms prior to signing of it. Hence, the terms are fixed by the law and no terms can be implied. This again shows how important HDA is in order to ensure that there is a prescribed form of SPA, and the property developers cannot take advantage of first-time home buyers who have no knowledge of how the law works and whether these are the general principal terms which can be excluded. Okay, this is a question by Hua. What would happen if the developers abandon the housing project? In the event if a developer abandon the housing project, they shall face a punitive punishment of a fine between RM 250,000 to RM 500,000, or imprisonment of a term not exceeding 3 years, or if it's a really serious one, he could be punished for both the fine and a jail term. It's HDA 1966, the only law that protects the home buyers. A strata title property buyer will also get additional legal protection under two other acts, i.e. the Strata Title Act 1985 and the Strata Management Act 2013. Hua also asked, can I do renovation only during the defect liability period? That's not true. However, it is advisable for buyers to make any defect warranty claims, if any, or engage in an expert to check before renovating. This because renovation could have concealed the defects that you could have reported to the developer, in which then might affect your warranty claims.
So there's this one question. Does the standard SPA applicable to all types of properties? Okay, as stated earlier, no. Only those that are protected under the HDA are required to follow it. So parties are free to negotiate their own terms and conditions of the SPA for the purchase of non-HDA properties. So just a recap, the properties that are protected under the HDA will be the residential title properties, except the fully commercial property. So let's see other questions. Okay, there's this question. Does defect liability period application to home buyers of non-HDA properties? If yes, how long? There is no fixed period and compulsory for the developer to provide the defect liability period. It is all subject to the SPA as agreed between the developers and the buyers. Okay, next question will be, is it on discretion of the developers for buyers to pay 10% of the purchase price upon the signing of SPA? Okay, so in short, no, because it is statutorily stated in clause 5 of third schedule that 10% of the purchase price to be payable immediately upon the signing of the SPA? So in short, the answer is no, because it's under clause 5 of the third schedule. JU, from JU, this question is from JU. When does the protection of defect liability period ends? The answer to this question will be after the issuance of certificate of completion and compliance, which is the CCC. So once the issuance of the CCC, the protection of defect liability period will end.
There's this question by Bailey Leong. If there is a delay in delivering vacant possession, apart from LAD, can I, as the purchaser, claim for loss of rental as well if I'm buying the property for investment purpose? Arguably, I would think that that would be quite hard for you to claim, because that would be duplicity of you claiming, firstly, the LAD, and secondly, the rental. I think it seems like, to me, I think it's a duplicity of claim. How can you claim for the same amount for the same period? Secondly, it might be too remote for you to claim that against your housing developers. So even if they give you the vacant possession, how could you guarantee that your property will definitely be rented as soon, like immediately after? So I think the short answer to that is likely no. Afika, do we have any more questions?
There's one more question from Rebecca.
I can't see it.
Yeah. Does newly launched property that has received certificate of completion and compliance has to use standardized SPA? So according to HDR 1989 regulations, the standardized SPA shall not apply if at the time of execution of the SPA, the certificate of completion and compliance CCC of the housing accommodation has been issued and a certified true copy of which has been forwarded to the purchaser. So this is the answer to your question, Rebecca.
Are there any other questions, Rachel?
Nope, I think we answered all the questions, Lisa.
Any other questions from the floor? If there are no other questions, I think we will end the webinar today. In the event if anyone who attended the webinar today have not asked any questions but would like to ask any questions, feel free to write into our general emails, which is enquiries@rdslawpartners.com, and then it will be directed to us, and we will try our best to resolve all your issues regarding the Housing Development Act. Thank you, everyone.
Thank you, everyone.